Kevin, it sounds like the decision of what's most appropriate, Chapter 7 or Chapter 13, takes a lot of thought. And you also mentioned something that I find interesting, is this idea of planning for bankruptcy.
Mm-hmm.
When I contact you, that doesn't necessarily mean that the most prudent thing to do is to immediately file.
Mm-hmm.
Tell us about that. How do you make the decision between which chapter to go to, and how do you plan for a bankruptcy, and what are the advantages?
Planning really is the key to bankruptcy. If you don't plan it, that's where things go wrong. The nice thing about the bankruptcy code is we know what the law is. We know what trustees are allowed to take to pay creditors with. We know what they're not allowed to touch. And when you come in and meet with us, that's what we do, is we really work on the planning on it. You know, most people come in and they're like, I got to file right away. I mean, they just feel like, I can't make the next credit card payments, we got to file before we make that payment. And you don't. When you meet with me, and if we decide that you're a bankruptcy candidate, one of the first things we do is we stop paying the credit cards. At that point, it's a waste of money. There is no point of paying them, because we are going to discharge all that money.
So right away that stops. I stop paying the credit cards.
Right. And that right there, that starts giving them an infusion of cash, because that's always something they worry about. How am I going to pay for it? Well, that right there helps towards paying it. That's why we take the payments. And so, you know, you stop paying it. Well, credit card companies are not going to sue you for about a year, 18 months after you stop paying. And the only way they can hurt you is if they have to sue you, they have to get a judgment, and then they have to get what they call a writ of garnishment issued from the court. And once they sue you, that whole process takes about 3 to 4 months. So we usually have a lot of time to plan a bankruptcy. There are a few cases where we don't. If you are somebody who's currently being garnished and you come in my office, that is one situation where we look to file you as quickly as possible. Because the best thing about bankruptcy is that on the day you file, all creditors have to cease collection efforts. They can no longer sue you. If they are garnishing you, they have to stop. And that's it. I mean, they are done. There's nothing more they can do. And then when the bankruptcy gets discharged, they're out of luck. I mean, their money is wiped away. And that's the few case. I mean, I think 1 out of 20 come in that we actually have to file quickly. The rest, mainly what it is to figure out, you know, it's kind of where you're at in your debt situation. If you come into my office and you're somebody who's behind on your home and you want to keep it and you can afford it, then, you know, we're looking at the Chapter 13. If you're somebody who wants to keep your home and you're current on their payments, ideally you're a Chapter 7. Because remember, in a Chapter 7, you can keep your house so long as you pay it. And that's mainly what the initial consultation is about, because there is no cookie cutter approach for your situation. I mean, people get there in similar ways, but it really depends on what you want to do. Some people want to keep their house and cars in a bankruptcy, and that'll dictate one path. Other people are fine. They're willing to let them go, and that makes the case a little different. And that's what I look at. I look at to see, what do you want to do? Because what I'm trying to do is find the solution you want. I'm not going to sit here and dictate what I think you should do. I mean, I'll give you some feedback if I think you're going the wrong direction. But what I want to do is tailor the bankruptcy to fit your needs. And then if you have any non-exempt assets, these are assets that are not protected, then that's where we do some of our planning, is we talk about, you know, what do you want to do with these? You know, vacant land. There's people that do have vacant land, and there's nothing I can do to protect it. What you do is you either sell it yourself at fair market value, or you have the trustee try to liquidate it. And sometimes we let the trustees do it, because if the trustee cannot sell it, the land actually goes back to you. And the common area I see that with right now is timeshares. A lot of people out there with timeshares. And it's something they want to keep, they use it, they enjoy it. And timeshares are unprotected. I mean, the trustee has the right to go out and sell them. And that's I'm talking about a timeshare that's paid off. If you're still paying on a timeshare, that's no problem. That's like a secured debt. You just keep paying that timeshare, you can keep the timeshare. But if you have a paid off timeshare, the trustee will attempt to sell it. But the reality is most trustees don't want something unless it's more than $1,000. They get paid on a commission structure, and if they don't get any money for it, they're not going to waste their time to it. And about $1,000 is their threshold. You know, if they can collect $1,000 of stuff, then it's worth their time to open a bankruptcy estate and administer assets. Well, what we're seeing with timeshares right now is they don't sell. If you go onto eBay and type in your timeshare, you'll be lucky to see a timeshare that sells more than $1,000. And so as a result, kind of de facto, is that people do keep timeshares because they really have no value with it. And so in that case, some clients are fine. I mean, they will just, put it down and go in the trustee meeting, see if the trustee wants to sell, and if they don't, they get the timeshare back.
So it sounds like the most important thing I could do is talk with you early, put together that plan for my specific circumstances, and decide what bills need to be continued to be paid and what that strategy is going to be.
Right. When you come in to see me, the best thing you can do is be open and honest and let me know what's going on. I need to know what kind of assets you own. I need to know what you've been doing with your credit cards the last 3 months before I meet you. Because we haven't talked about this yet, but with credit cards, if you have a single charge more than $500 on a credit card, or a cash advance or cash transfer more than $700, it raises the automatic presumption of abuse, meaning that you used that card with the intent to file bankruptcy. And if I don't know about it and we're going through the bankruptcy process, the credit card has the right to object to the discharge of the amount of debt that you charged on the credit card within 90 days. I had a client who was doing that, and he never told me about it. And he was doing cash advances of about $2,000 a month within the 90 days prior to filing. And as a result, he had to enter into a settlement with the credit card company where he had to agree to repay that $6,000 over a 2-year period.